Hi everyone, I'm Jin Hee Lee, attorney licensed in Korea and a registered foreign legal consultant in California. Now I'm practicing based on LA area doing mostly business transaction M&A with Korean companies and also any kind of Korean legal practice. Today is the third day following what is M&A and why M&A. Last time I talked about the beauty of M&A and this time I'm going to talk about the risk of M&A by telling you the risk you should consider at the M&A process and how you handle the risk. Let's begin with the deal structure first. The deal structure would be the first stage of M&A process. Last time I talked about the components of M&A, the buyer, seller, target, price. The deal structure is what you make the structure of the buyer, seller, target, the price. Of course, as the M&A process goes, it can be changed, but this is one of the topics you discuss in the beginning. At this stage, you must consider the purpose of the deal, taxes, and validity under the current law. There are some M&A cases that the companies pay taxes that they would not pay if they review the deal structure, found and take care of the risk. Or they had to do other M&A again to avoid the legal issues since the corporate governance of the companies was illegal after the M&A because they didn't take care of the risk of the deal structure. That is, if you don't take care of the risk, you pay off too much. And next step is due diligence. Actually, I can talk about the due diligence all day because this is so important. During the due diligence, you find risk. That's the first step. Reviewing documents, interviewing with target company's employee, the Q&A session, the management presentation, site visiting, or any kind of researching. And next step is evaluation. What I mean is that you evaluate the risk that you found at the due diligence, whether the risk is a deal breaker or whether the risk can be reflected in the valuation or whether you can defend or mitigate the risk. If a risk is a deal breaker, you may let the client know that the M&A case should be or may be dropped. If you can reflect the risk to the valuation, the price, you may request to reduce the price. Or you can add or mark up the M&A agreement to defend against the risk or mitigate the risk. I gotta tell you one story. There was a cross-border M&A case that I deeply involved. I represented the Korean big company who was the prospective buyer. Actually, the reason of the M&A was the target technology, but during legal due diligence, I found that the target got sued from other company and the other company claimed that the target's technology infringed the company's technology, so damaged. The amount of the lawsuit was almost 50% of the purchase price of the M&A. It's huge, so the buyer, my client, asked the seller, what's going on and what's your plan for this lawsuit? And the seller answered that it's not a big deal, and they said they're gonna win, so we don't have to worry about this. But as the buyer and our law firm conducted due diligence more and reviewed, assessed, and evaluated the lawsuit, the amount was not the only problem. As a result, the chances that the target company win was 50-50% or less. Also, the plaintiff was the competitive company, so if the lawsuit was going on, it would be very seriously harmful to the target company's business, even after this M&A. So the buyer and our law firm had to consider everything, every possibility, and then we offered that the seller to settle with the plaintiff before the execution of M&A agreement. Also, the settlement should be what the buyer expected to. I cannot say the details more here, but when I look back in the day, everything was not easy, complicated. We had to think about every situation. But finally, the target and the plaintiff settled, and later the M&A was closed. I felt so grateful about that case. I know it depends on the market situation, whether a seller market or buyer market, also any other circumstances. Basically, the most important thing is that you should find, evaluate, and take care of the risk. The M&A lawyer must negotiate everything for your client's best interest. Okay, today I've talked about the risk of M&A and how to handle this. Next time, I'm going to talk about more about the risk after the execution of M&A agreement and how to handle the risk. If you have any questions about the content today, M&A, business transaction with Korean companies, investment in Korea, or any kind of Korean legal issues, just scroll down and leave a message, or you can send me an email as well. Hope you enjoy the content today. See you next time. Thank you.